Hello, I am David Fye, Executive Director for the Kansas Behavioral Sciences Regulatory Board. And I ask the members of the Professional Counseling and Advisory Committee's Subcommittee on Unprofessional Conduct Regulation Review to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. Bob Kircher.
Here.
Andrew Secor.
Here.
And then the following BSRB staff members are also present. I am Executive Director David Fye, and Leslie Allen is also present, the Assistant Director and Licensing Manager for the BSRB. Next, I'll read a message about this meeting being held remotely. Public comment allows the public to address the subcommittee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the subcommittee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment can contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting as no individuals requested to provide public comment. Because we're conducting this meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of KOMA are not suspended, so we will be conducting this meeting pursuant to the KOMA. On September 23rd, 2022, we sent notice of the subcommittee meeting to all individuals who had requested notice of board or advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting material have been posted on the board's website. And you can request a copy of the agenda by sending an email to david.fye@ks.gov with a subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240 or send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And so the meeting is now called to order, and the advisory committee's subcommittee will begin its discussion with the first item. And this subcommittee is dedicated to reviewing the rules of unprofessional conduct for the professional counseling profession that is regulated by the BSRB. And we do have sufficient members to go ahead and begin the meeting. At the last meeting, we went through the rules of unprofessional conduct, and we had gone, this is Kansas Administrative Regulation 102-3-12A, unprofessional conduct. And at that meeting, we went through and reviewed the rules of unprofessional conduct from 1 through number 27. And so today we can go ahead and start with examining number 28. And then if the time allows, we can go through the remainder of the rules of unprofessional conduct. The materials you received, you do have a copy of the KAR 102-3-12A. Additionally, you have a copy of that regulation with a few items highlighted or marked up. And these were proposed changes that were talked or discussed during previous meetings, the Professional Counseling Advisory Committee in previous years. So there's a couple of different regulations that have notes, and I'll highlight those when we get to those items. But otherwise, I'll go ahead and share my screen, and we can just kind of go through the regulations. And if you have suggestions on possible changes, one of the items that the subcommittee is doing is looking to see, is the language still consistent with acceptable practices in terms of what would constitute unprofessional conduct? Is there language that needs to be added? Is there language or items that should be removed? Or are there things that are vague or ambiguous that need to be clarified? Additionally, with changing technology, are there items that really need to be clarified in the area of telehealth or social media or different things like that related to changes over time and technology? So with that said, I will go ahead and share my screen, and then we can take a look at the unprofessional conduct regulations. Okay. Can you see the set of regulations on my screen? Okay.
Yes.
Great. Okay.
Yes.
Well, as I mentioned last time, we were able to get through the items 1 through 27. So we could start with item number 28. And I'll just go ahead and plan to kind of read the regulation. And then if there's any comments, we can consider that. And ultimately, what the subcommittee has authority to do is make any kind of recommendations back to the advisory committee. So we'll just be highlighting items that potentially recommendations could be forwarded to the advisory committee for discussion, and then potentially those could be forwarded from the advisory committee back to the board for potential changes. So number 28, and just for preface, it basically says that any of these actions would constitute unprofessional conduct under the regulations for the board. So item 28 is directly or indirectly offering or giving to a third party, or soliciting, receiving, or agreeing to receive from a third party any fee or other consideration for the referral of the client, or in connection with performing professional counselor or clinical professional counseling services. Any comment on number 28?
I'm trying to understand what situations this might involve. Offering or giving to a third party, or soliciting, receiving, or agreeing to receive from a third party any fee. Oh, so that means like the professional will be getting a fee for sending people elsewhere. Okay, I was reading
For the
that.
referrals. Yeah.
Right. Yep. Nope, that makes sense.
Okay. Then we can go on to item number 29. It would constitute unprofessional conduct for a practitioner to permit any person to share in the fees for professional services other than a partner, employee, associate in a professional firm, or consultant authorized to practice as a professional counselor or clinical professional counselor. Any comment on item 29?
No.
Okay. If not, we'll go to number 30. Number 30 states soliciting or assuming professional responsibility for clients or other agency or colleague without attempting to coordinate continuity of client services with that agency or colleague.
Yeah, that's pretty much what's in the ACA code. So,
Okay. We'll go to item 31. Making claims of professional superiority that one cannot substantiate.
No change for me on that one.
no.
Okay. Number 32, guaranteeing that satisfaction or a cure will result from the performance of professional services.
No change.
Yeah, no change for me either.
Number 33, claiming or using any secret or special method of treatment or techniques that one refuses to disclose to the board.
I wonder about the wording, like secret, or special method. And, Bob, I'm wondering like if this is getting to the idea of like not approved types of treatments or so forth. And if there's different language that might be, I'm trying to look in the code here to see. I know there's an issue around this about like experimental treatments and so forth.
Right.
And trying to see where it talks about this. Maybe untried or experimental, or I don't know. What do you think?
Yeah, I would think that, I don't think that the word secret is I'm not sure how that got there in the first place, to be really honest. Other than maybe they're trying to keep a secret from the board.
Right.
That's the only context I would see it as. Yeah, it would be helpful if it was clarified some. Don't know how to do it though.
Okay.
Yeah, it's almost like we're saying, I don't know if this is met elsewhere because I know we haven't been through the rest yet, but it's almost like this is getting at the idea that the provider shouldn't be, because there's one issue of consent where the client needs to be made aware of the type of treatment that they're getting, and if this is a proven or experimental or an untried treatment, so they can consent. But this is looking at the idea that the board would need to know, and I guess understanding what circumstances, like most of us don't tell the board what therapies we're using. So I guess I'm wondering, unless we're being investigated, right? If there's an investigation, the person doesn't share. So I wonder if it's just like claiming or using that they're using any form of treatment or technique that they're not disclosing to the board. But it might be helpful to know where the secret or special method came from, because I imagine this was there for a reason. But maybe we just need to change a word, secret, special method, to be more in line with today's languaging. Experimental, like if it says special method, maybe that would be experimental.
Right.
And then secret, maybe claiming or using any undisclosed or experimental method of treatment or technique that hasn't been shared with the board or disclosed to the board. I don't know. So it may be something to bounce around a little bit.
Okay, well, I will highlight that item for possible wording changes based on the comments that you both have made.
Okay.
Number 34, continuing or ordering test procedures or treatments or using treatment facilities or services not warranted by the condition, best interests, or preferences of the client.
In general, I think it's okay. I do wonder about the use of the word tests. If we need to use a different term to distinguish from the types of tests that a physician might use versus the types of like standardized instrumentation that could be used. But at the same time, there's psychological assessment is more the common term that we use. So continuing ordering assessments maybe versus tests. I don't know, Bob, if you have an idea, thought about that.
Yeah, that was the first thing that came to my mind when I saw tests. It was like, well, we don't really call it that. We call it assessments, which is a more generic and overview term that includes lots of different things. Mm-hmm. So rather than simply standardized tests. So
right.
I would say assessments.
Okay. Looking at item number 35. And 35 is a lengthy one, so we'll go ahead and just kind of start it here. Number 35 says, failing to maintain a record for each client that conforms to the following minimal requirements. A, contains adequate identification of the client. B, indicates the client's initial reason for seeking the services of the professional counselor or clinical professional counselor. C, contains pertinent and significant information concerning the client's condition. D, summarizes the interventions, treatment, test, procedures, and services that were obtained, performed, ordered, or recommended, and the findings and results of each. E, documents the client's progress during the course of intervention or treatment provided by the professional counselor. F, is legible. G, contains only those terms and abbreviations that are comprehensible to similar professional practitioners. H, indicates the date and nature of any professional service that was provided. And I, describes the manner and process by which the professional counseling and clinical professional counseling relationship terminated.
I would say that on letter D, where it says tests, again, I would say assessments.
Yeah, I agree.
Okay. So in some of the other, I guess this would be maintaining a record for each client that includes this basic information. So on some of the other record keeping regulations for the other professions, there was some conversations about if something would need to be noted in terms of whether the relationship was in person therapeutic or whether it was done by telehealth. So I don't know if this would be an area that would fit under this regulation or if this is something else just concerning the record itself.
Yeah, this is fairly vague because I look at, for instance, I think it leaves a lot of openness for people. Some folks, when you look at like how things were terminated, folks will have a formal discharge summary, right, that explains everything. And then there are others that just write it in a note. And depending on training and so forth, I look at that and I think there's a lot of variety that this opens up to in terms of, I guess, as long as the information is there. Is that all we're going for? Are we going for a clinical best practice in terms of how that could work, or that we leave that mainly to our professional entities? But for the telehealth piece, I think that would probably fall under potentially D. Could be where they indicate the type of, I guess it would be the method in which the service was delivered. So it might be
mode,
service delivery. Whether that was telehealth or whether that was in person, maybe that could fit there and in that area. But
And you did have a comment about if these are, if we're looking for best practices here, or if we're looking for a different standard, and that's kind of been talked about with some of the other advisory committees too. I think there is a ground between, best practices, and then there's an area below that, and then there's an area below that, which is, if you fail to meet these standards, that would constitute unprofessional conduct. So I think that there's, some area of not preferred that may not constitute unprofessional conduct, but I know also on some of these, they are written in such a way that allow the complaint review committee of the board to weigh the facts of each independent scenario to evaluate everything together. So I do think that there is a difference between, we're not necessarily looking for best practices in the unprofessional conduct regulation. It's really more of what would fall low enough that it would constitute being unprofessional conduct too. So
yeah, that makes sense.
Yep.
Okay. Any other comments on the other items under 35?
No, I don't see any.
Okay. We'll go to item number 36. So item number 36 is taking credit for work not personally performed, whether by giving inaccurate or misleading information or failing to disclose accurate or material information.
Yeah, I think it's appropriate. Yeah.
Okay. And so the next item number 37, there were some possible changes on a copy that was looked at in the past. So I'll go ahead and go through what we currently have, and then I will change to the marked up copy of this regulation to see if you think those potential changes would be helpful, or maybe if different changes would be helpful. So item 37 states, if engaged in research, failing to fulfill these requirements. A, consider carefully the possible consequences for human beings participating in the research. B, protect each participant from unwanted physical and mental harm. C, ascertain that the consent of each participant is voluntary and informed. And D, preserve the privacy and protect the anonymity of each subject of the research within the terms of informed consent. So that is what currently is in item number 37. And I'll go ahead and change to the other copy of KAR 102-3-12A. So the marked up copy of 37 had some different language that was being proposed by a different group. And so the language that they had considered was failing to consider the possible consequences on participants, failing to take all reasonable precautions on behalf of participants' welfare, or causing emotional, physical, or social harm to participants throughout the research process, according to all current state and federal laws and statutes for conducting research. And then it would strike through what had previously been included under A, B, C, and also D. I'm curious if you have any thoughts on the way that 37 is currently worded, and also the potential change that another group had considered before now.
I think the potential change that's listed there is much more concise in some ways, combining those. I don't know. Need to think about the wording, specific wording here for a second.
Yeah, I do have I wonder about the removing of the C when it talks about voluntary and informed, like the consent piece. I do think that it's important to leave the part about informed consent in there, just so that it's explicitly indicated. Like that's a key to any research process. So I do like the idea of being more concise, but I wonder if this communicates what A through D were communicating beforehand, because there is, it is different in terms of looking at like current state and federal laws, statutes for conducting research. I mean, it's fine to say we want to do that according to that, but there are certain basic elements that people need to know, that if they didn't do this, like you were suggesting earlier, David, or stating earlier, like if we don't get informed consent, if they don't know it's voluntary, if they don't recognize like protecting anonymity is important, which of course, if you're going through and you're doing your human subjects research training, those are things that you would know. But at the same time, I feel like removing those specific items from the language makes this really, in some ways, vague, whereas I think that part of it would be important to have. I don't know, Bob, what your thoughts are, but what others are doing. Like oh, go ahead, Bob.
No, I'm just trying to figure it out. I'm also looking on a hard copy of it. I'm going back and forth.
Yeah. So I'm looking at the ACA code right now, and they have things such as, confidentiality in research. So it says that their counselors are responsible for understanding and adhering to state, federal, agency, or institutional policies and applicable guidelines regarding confidentiality and research. That's G1B in the ACA Code of Ethics. So there's some language there that I think is what they might have been getting at the end of that. There's even talk about independent researchers, that people that don't have access to an IRB. So like what's considered, do we need to go so far as to talk about, do the same things apply, whether it's independent researchers or people that in an institution doing work, at least to say that they're bound by the same expectations and federal laws, which that may be covered at the very end as well, just by saying that. Go ahead, Bob.
Can we refer to the Professions Code of Ethics in this document, David?
So we can use the same language that's included.
But we can't really refer to directly to the current ACA Code of Ethics.
We've been advised not to.
Okay.
There could be future
That's what I was trying to
changes.
figure out.
Yeah, and so we wouldn't want to tie ourselves to something that we didn't have direct control over,
Yeah.
because there could be a change
Yeah.
that the board may not agree with, but then if we tie it to that, that could be something that might bind us potentially. So
Sure.
But we could use the same language. And so, you know, at a certain point, words are just words. And so if there was some phrases we might want to pull over, we could definitely do that.
Mhm.
And it's a little different with federal laws and statutes because, you know, as an agency under the state of Kansas, we were created by statute and we are held to not do anything that would be unlawful. And so it's a little bit different.
Yeah, I'm looking at the 37, the new writing of 37, and I'm not sure how we can adapt that to do all those things that really need to be included, I guess.
Yeah, I think there's also a piece of this too. You know, it has the language here according to all current state and federal laws and statutes. And while that might cover a lot of practices under those state laws and federal statutes, I think the question would be, is there enough visibility on what those would include? Because we want someone to be able to look at the unprofessional conduct regulations and be able to understand, you know, what we're asking them to be held to in a general sense. And so maybe highlighting things specifically might be helpful in terms of more visibility on some of those things too. Well, I will highlight this item, and maybe this could be something that is discussed in front of the full advisory committee, and maybe they can get some additional comments on this item too, since it is kind of an interesting item. So,
Yeah.
okay, well, I'll switch back to the regular regulations, and we're about to look at item number 38. 38 is making or filing a report that one knows to be false, distorted, erroneous, incomplete, or misleading.
No change.
Change.
Okay. Number 39, failing to notify the client promptly when termination or interruption of service to the client is anticipated.
No change.
No change other than promptly leaves a lot to be interpreted there. I'm not sure what you would do otherwise.
Yeah, it seems like the word promptly may be there on purpose because what's considered prompt is going to vary by situation.
To situation, yeah.
And it may be
I agree.
within a reasonable time frame. I mean, I don't know, but I know you all need to leave space for when things are looked into to be able to have that space to determine what would be considered prompt or reasonable.
Yeah.
Okay.
So no change from me.
Okay. Then item 40, failing to seek continuation of service or abandoning or neglecting a client under or in need of professional care without making reasonable arrangements for that care.
No change.
No change.
Okay. Number 41, abandoning employment under circumstances that seriously impair the delivery of professional care to clients and without providing reasonable notice to the employer.
Yeah. No change from me.
Yeah, no change.
Number 42, failing to terminate the professional counseling or clinical professional counseling services when it is apparent that the relationship no longer serves the client's needs or best interest.
No change.
Yeah, no change from me.
Okay. Number 43, if the professional counselor or clinical professional counselor is the owner or custodian of client records, failing to retain these records for at least 5 years after the date of termination of the professional relationship, unless otherwise provided by law.
So I do have a question about this one. There's a lot of variation in states about the maintenance of records after termination. Do we have a specific, sometimes they say like once a person, if it's a minor, it's 18 plus 5. Would that be the way that it's viewed? Like, so we're with minor clients and they're 13 or 12 years old. Some people expect that you keep it for however many years plus however much after they would become an adult, or is this just 5 years no matter what age the person is. Do we know the answer to that?
I recall some other conversations by the advisory committees that there are special rules if someone is a client that is a minor. And I think you're right on that. I think it is, there's different rules until they reach the age of 18, or usually until they're considered to be an adult. So I think this would probably be a general standard. And then the part about being a minor would probably fall under the unless otherwise provided by law. So,
Okay,
Some of the other regulations specify that you're supposed to keep a minor's records longer.
you said none of them specify that?
Some of them do.
Well, some of them do.
Mhm.
Because I would be curious, because this would be, I hear a lot of questions about it. And there's not really a place that folks can easily go to know that they might have done, well, what not to do, right? Because essentially this tells us
Right.
what we should do. And I don't know that's indicated anywhere else. So if there are others that specify it, it might be helpful to know what those say, to see if we want to include that here with ours also.
okay. I'll put a note about that to have some language about how minor records should be treated as well. Item 44, supervising or directing in a negligent manner anyone for whom one has supervisory or directory responsibility.
That word directory was a little confusing initially. When I saw that, I thought, wait a second, but supervising or directing in a negligent manner. So that this leaves it pretty open, because I am concerned about protecting supervisees. And does this also include, this also includes students as well, I assume, because it just says anyone for whom they have responsibility. So I imagine this would respond to, like, if there's supervisors that are supervising student interns too.
I would assume based on, well, I would assume so. If the person is a licensed person, yes.
So we have asked legal counsel for a little clarification on the word supervisor and supervisory. They've said as it relates to purely an employment position in terms of a supervisor there, it wouldn't apply unless otherwise stated as it would apply to a supervisory employment position. But otherwise, as it relates to their providing supervision in the context of their license to individuals, and that would be what it would refer to in this context.
So just speaking in simple terms, like if a university professor or a site supervisor was supervising a student intern, would this apply to them? As you understand it from legal counsel.
And yeah, I might have to get back to you on that one, unless Leslie, you have any comments on that scenario. But and Leslie might have stepped away, but we can get back and clarify that. So
No, I don't know of anything.
okay.
Because I am concerned about students not being protected by if something were to be done that was negligent, and maybe like if a supervisor attempted to initiate a relationship improperly with a student, that's a supervisee in training, and they're the person in charge. Like to me, it seems like we should have something that allows for recourse for that type of improper use of the supervisory role by a licensed person with another individual. So if nothing in this covers that, then I would say we need to include something new that would provide safety. First, we have stuff when it comes to research with students and education with students. Like, if they're not protected from their supervisors, then what do?
Right.
Okay. I've made a few comments here, and we'll talk with legal counsel a little bit and get some clarification on that.
Thank you.
Number 45, failing to inform the board, failing to inform a client if professional counseling services are provided or delivered under supervision or direction.
No change.
No change.
Number 46, engaging in a dual relationship with a client student, or supervisee.
So yeah, we have student mentioned here.
Right.
So it seemed like it would be easy to say providing negligent supervision, to anyone, right? That student, postgraduate or licensed person. It'd just be interesting to know the difference between being able to list student here versus referring to a student in another part of it. So I have no change to this one, but I just wanted to mention
No.
with 46 saying student specifically, that might be useful to consider.
Yeah, no change to this one as far as for me.
Okay. Number 47, failing to inform the proper authorities as provided under the specific statute and amendments thereto, that one knows or has reason to believe that a client has been involved in harming or has harmed a child, whether by physical, mental, or emotional abuse or neglect by sexual abuse.
I would just change, I think that sexual abuse should be included with the physical, mental, emotional, or sexual abuse, and then neglect be included after, because the way that it's listed in, like, even with the handbook that DCF puts out, they list the forms of abuse, I think, together, and then neglect, of course, has two different types of neglect, but I think if it said physical, I think, is mental and emotional abuse the same thing? I think it's maybe sometimes we can leave it as separate, but I wonder if psychological abuse is what that's, but we can leave it. But I would just like to move sexual abuse with the other forms of abuse and then neglect come after.
Yeah, I would agree. That should be moved with the physical, sexual,
Mm-hmm.
mental, or emotional. Yeah, I'm not sure what they were referring to as being separate in mental or emotional. But
Okay. Number 48, failing to inform the proper authorities as required by the statute and amendments thereto, that one knows or has reason to believe that any of the following circumstances apply to a resident, as defined by the statute and amendments thereto: has been or is being abused, neglected, or exploited, is in a condition that is the result of abuse, neglect, or exploitation, or is in need of protective services.
I don't.
I wonder what are those statutes that they're referring to?
I imagine they're probably the mandated reporting guidelines, but I don't know for sure.
Mandated reporting, I believe.
Okay.
I'm looking at the DCF guide to reporting child abuse and neglect to see if, because they refer to physical abuse, sexual abuse, emotional abuse, and neglect is how it's referred to by the state of Kansas Department of Children and Families. And I'm trying to see if they list the statutes. Looks like KSA 38-2202 is the physical abuse statute. So I don't know what 39-1402 is, or 1401, unless that actually may be the mandated reporting, like you said, and then the other ones are specifically defining what physical abuse is, sexual abuse, and so forth.
Okay, we can check those
Any
statutes
changes?
to see if there's any changes in recent years, but because the professional counseling regulations were last updated, I believe back in 2008. So there may have been some additional changes there.
And David, what I see here, it says Kansas reporting laws, mandated reporters, and it listed as KSA 38-2223. And so, yeah, I'm not sure what those others would actually, unless there's been a different change. So yeah, it'd be helpful to know what they are and what they're referring back to, but within the context of the DCF guide, as it referred to language, they use physical abuse, sexual abuse, emotional abuse, and neglect are the different forms that are listed with that, but we can certainly leave it the same.
Okay. Okay. I'll take a look at that statute to see if there's been any changes since the regulations were last updated. Number 49, failing to inform the proper authorities as required by that statute. And amendments thereto that one knows or has reason to believe that any of the following circumstances apply to an adult as defined by the statute and amendments thereto. A is being or has been abused, neglected, exploited. B is in a condition that is the result of abuse, neglect, or exploitation. Or C is in need of protective services.
No change for me.
No change for me.
Number 50, intentionally or negligently failing to file a report or record required by state or federal law, willfully impeding or obstructing the filing of a report or report required by state or federal law, or inducing another person to take any of those actions.
No change.
You still thinking about that one, Bob?
No, no change. Sorry.
Okay. Want to make sure. Number 51, offering to perform or performing services or any service, procedure, or therapy that by the accepted standards of professional counseling or clinical professional counseling practice in the community would constitute experimentation on human subjects without first obtaining the full, informed, and voluntary written consent of the client or the client's legal representative or representatives.
It's interesting that that is separated out from the other one.
I was going to say, this sounds like something we were talking about back at the beginning, addressing this here. Can't remember which one that was that we were referring back to.
Yeah, and I believe that was number 37.
I think it was 33, the secret or special method.
Oh, right. Yeah.
I think we were talking about that, which maybe they're two different things, which is why they're separate, is that number 33 refers to something different than the idea of what we have here. So I don't have any changes to this, but
No.
I thought the same thing, Bob. I guess if we're wondering if they're two different things, it might be helpful for us to find out, just that way, if it's confusing to us, it might be confusing to other professionals. So
Sure.
But that was also, we had discussed those issues within number 37 as well, I believe.
yeah, research, yeah.
Okay. It's difficult to go back and look at some of the history on some of these changes, especially now that it's been over 14 years since last time they were modified, but I'll take a look to see if I can find any record of maybe some of that past discussion. Number 52, practicing professional counseling or clinical professional counseling in an incompetent manner.
No change.
Change.
Number 53, practicing professional counseling or clinical professional counseling after one's license expires.
No change, but did we talk at one point that other committees were considering an extension, a particular extension to apply for their renewal?
So I think what's been talked about is the licensed psychology profession has a regulation that allows you to request more time to complete your continuing education hours. And so if you are granted that, you are allowed to renew your license. And then even though you are in the next renew cycle, you still have some time to make up the hours that you were to have completed during the past license period. So you would still have an active license. You would have renewed before the deadline. You would just have additional time to complete those hours. Otherwise, under the normal circumstances, you have to have them completed before you renew your license.
Right.
So that's kind of how that would play into it. And there was a little bit of confusion about that because there was some language that said you can get additional time to complete the hours. And some people thought that was just an extension of their license. And so we had to clarify that we don't have authority to grant additional time for the license. We can't extend the license period. But what we can do is allow you to renew your license, but you get additional time to complete those hours.
Oh, okay.
Because the law says that every 2 years you have to, so you can't allow the time frame of it, but you can renew. And then, so as a person's license, then that would be inactive in that sense.
So how it would work would be that they would they would renew their license, and when they renewed, they would indicate how many continuing education hours they would have. And then normally that would automatically get pulled for an audit if they renewed with an insufficient number of hours. But because we have that on record, we would go ahead and allow them to process the renewal. And then they have a certain amount of time to do those hours. And so if they don't do those hours within the acceptable amount of time, then they would essentially have a report of alleged violation filed against them by the board for failing to complete the hours and not being consistent with that regulation.
Okay.
Number 54, using without a license or continuing to use after the expiration of a license any title or abbreviation prescribed by law for use solely by persons currently holding that type or class of license.
No change.
No change, generic enough. It probably fits all different licenses, but yeah.
And then 55, there was some proposed different language for that item. So I'll go ahead and read through what's in the current regulation, and then I'll talk about some of the proposed language. 55 states diagnosing or treating any client who a professional counselor practicing under direction of a clinical professional counselor has reason to believe is suffering from a mental illness or disease as opposed to a mental disorder. And so the proposed language that has been considered in the past for this item would change that language to state practicing inappropriate boundaries with clients with regards to use of social media, including but not limited to using a personal profile to connect or communicate with clients on any social media platform, or accessing a client's social media page without previous consent. And then there were some additional items that were added that I believe would also kind of follow under this same idea. So
the thing about diagnosing was just struck.
Well, yeah, that seems like two different things.
It does.
Like 50,
Does to me anyway.
yeah.
I think there was
stay as it is, and then the additional language would become a new regulation. I think would be best in that particular case.
Yeah, so it looks like there's 3 additional regulations that they had talked about. So I guess the old language of 55 is really kind of a little independent. So do you have any thoughts on maybe I'll go back to the original language of 55. Do you have any thoughts on the language of 55?
I do think I struggle with, this is one I've had trouble with, because the idea where it says has reason to believe is suffering from a mental illness or disease versus a mental disorder. And I think sometimes we look at this and the idea here, I think, was that it separated out what psychiatry was doing, like doctors and health professionals versus mental health. But then the question I look at this, say, if a client is dealing with, like we would say, is a mental illness, maybe something that's more biological, such as schizophrenia, does this say that a professional counselor couldn't treat that person? Like, it may mean that they need to refer to a psychiatrist for medication evaluation, but how are we differentiating between mental illness or disease versus mental disorder? I know the DSM includes schizophrenia, which some would say is a mental illness, but it's also included in the DSM as one of our conditions that we're trained to understand and work with. So I think this 55 could create a lot of confusion about separating out what we can treat and not treat. I wonder about that. Bob, do you have any ideas? And maybe I'm overthinking that.
No, I don't know why that would have been that way, other than to that was part of the agreement as such at that time, so that counselors could diagnose and treat. Maybe, I don't know. Is that directed toward a specific statute, and is that the way that the statute reads? Maybe.
Yeah.
There's no reference to a statute in this one.
It would seem to me like, if we don't really understand what this is saying, that this could eliminate, if we took this literally, and we said mental illness or disease, I would look at that being things like bipolar disorders, psychotic disorders such as schizophrenia, brief psychosis. This could eliminate things such as ADHD, since it's a neurological condition versus a mental disorder. Even though it's in the DSM. So I'm looking at this thinking mental illness or disease could be, we talking about dementia? We talking about, those types of things, traumatic brain injuries, in which case we would still be able to treat folks like that with those conditions under our training. So I wonder if that all just needs to go away, and it would be more of like you're diagnosing and treating someone with a medical condition or disease which not trained. I mean, I don't know, but it seems like this may be outdated, because if not, then we start really slicing up what within the DSM providers are actually able to work with based on what's considered to be a psychological issue versus a biological issue.
Right. So is that what the in the proposed change that was there, is that what they were essentially doing, was taking out 55 and putting in a new 55 unrelated
Right.
to that,
Mm-hmm.
to add to, but that's where it would go. I
Yeah,
don't know.
that's what I'm wondering now. As I really look at that last line, maybe they were just creating a new 55 and eliminating that.
Right.
Yeah, because I would be for, if we don't know the reason why that's there, I had seen that before, and I would be for getting rid of that, because I don't think we have that separation anymore, like historically existed between disease and disorder. Mental health providers work with folks with all of these things, right? We're just expected to coordinate care with other professionals that are serving them as well, to ensure that proper care is being delivered.
Right.
But as long as we have the training, I mean, I don't see the difference between that. I don't know how the 55 should stay.
Okay. Well, I'll highlight it for possible removal, and I'll try to see if I can get any kind of background a little bit more on this one specifically. I know we're right at time. You guys have a few more minutes to go through the three additional proposed ones, or okay?
Yeah, sure.
Great. So there were three new possible additions that have been considered before. The first dealt with practicing inappropriate boundaries with clients regarding the use of social media, including but not limited to using a personal profile to connect or communicate with clients on any social media platform, or accessing a client's social media pages without previous consent.
I do think that having something surrounding how therapists engage or counselors engage with people because of the social media presence, I think that it would be important to have more in here about technology. You know, if there is something that says that we're not supposed to seek out or research our clients. And I know that there are lots of counselors that do, and the ethics say ethically we shouldn't be doing that for various reasons without their prior consent and so forth. So I would say that I wouldn't have a problem with it. But that doesn't mean anything.
Yeah, I think that that's an appropriate thing to be in there, to be real honest.
Okay. Number 56 said disclosing confidential information through public social media.
No problem with that one.
Yep, me neither.
And 57 says if engaged in distance counseling, failing to fulfill these requirements. A, informing the client of risks and benefits of distance counseling. B, disclosing the possibility of technology failure and providing alternative methods of service. C, detailing emergency procedures to follow when the counselor is unavailable. And D, taking appropriate steps to encrypt and ensure the security of confidential client information or any activity that protects confidential client information from risk of privacy breach.
Yeah, I'm all for adding more stuff on telehealth because our act itself is too vague, and we don't have really anything within our existing standards that cover telehealth. I know they pulled this from the Code of Ethics, and I think that it wouldn't be bad for us to review the entire H.2.A in the Code of Ethics as we consider how much we want to add. Because I would be for all of these things, plus maybe even some more that is listed there that talk about, I'm looking at things like credentials for doing distance, like disclosing like any counseling, like the training credentials you have. Like we're supposed to do that for regular in-person therapy. I wouldn't have a problem with adding the fact that before you engage in this, clients should be informed of what your distance counseling credentials are. Have you done training in telehealth? Ethically, we're supposed to have completed training before we deliver telehealth work because it's a different mode of therapeutic engagement. So I would be okay with that. What's the physical location of my practice and contact information so that people would know how to find us or reach us in those sense. So it talks about time zone differences. I mean, we have 3 counties in Kansas that are not on central time, they're on mountain time. And so being mindful of those things, cultural language differences that could affect delivery of services. Anticipated response times, if that's not listed here, like how long a client could expect to hear back from you. Because if these folks are not running just a practice, but let's say they're doing BetterHelp or Headspace or these different things that people are being contracted for in the state, what that even looks like. So I would be okay adding some additional language to beef up what we have for telehealth to ensure that that we're really protecting consumers of telehealth services, because I feel like right now it's been a very, very open, and I've been concerned about a lack of consistency in the way providers are applying this in our state.
Yeah, I would agree. I'm not sure how we would identify each of those categories, however, at this moment.
Right.
But I would agree. I believe we need something way more than what we have.
Yeah, I mean, there's an entire section H of the
Right.
code
So I'm reviewing right now.
Right, that's what I'm looking at, that we might want to review to consider an entire addition into this part of our work and how we might want to consolidate that and condense it. But I really do think that could be a guide, not necessarily that we adopt that, but that we use that as a helpful guide to consider at a minimum, right? I think we're talking about what's minimum level things that we want people to do to ensure that we're protecting the consumers of their services. And section H would be an area that we could refer to that might help us with that, with a conversation with the larger advisory committee.
That sounds great. Yeah, the Kansas legislature has made comments about wishing to have more detailed telehealth standards. And I know that this is only a piece of it because this is talking about what would constitute unprofessional conduct, but I think the comments you made are really helpful. And I think it's not, I mean, it's probably going to, be reduced from what it was back in 2020, but it's not going to go away. And I think it has remained fairly popular. So I think having good standards in here would be helpful. So.
And I would be happy to speak with any groups that are, or work with groups that are addressing that. Because that's been an issue I've long held and shared, that I don't think we have real good standards beyond what's listed in the act. That's it. I mean, that's all. So that's why I think if we can do something here, we at least get the ball rolling and protecting the public and ensuring counselors know what's expected, but then really defining and narrowing, kind of, I wouldn't say narrowing, but defining what this means, that we have good protection within our state.
Yeah, sounds good. The last item is number 58, and 58 just says violating any provision of this act or any regulation adopted under it. So I think that's just a helpful clause there at the end as one last item. But I appreciate both of your work. I think what I'll do is I'll take our comments today and the items that you had highlighted for changes and recommended changes, and we can talk more with the advisory committee. There's a meeting on Monday, so I'll kind of turn this around, and so then we can talk a little bit more and provide an update on the subcommittee. But I appreciate both of your time and going through all of the unprofessional conduct regulations. And we can just kind of summarize our work here and then add some additional comments back when we get before the full advisory committee. So.
Yeah, thank you.
Thank you. All right. Have a nice day, guys.
Thank you.
Have a nice day.
Bye.
You too, Leslie. Bye-bye.
Bye.